Hey y'all, Rob here with ATX Legal and here with the next part of my Travis County DWI guide for 2023. And in this video, I'm going to talk about trial. Now the first thing to think about with trial is it's very rare in DWI cases. I would say less than 10% of cases go to trial. And there are a lot of reasons for that, and we will go into that. But the main reason is we usually get a better offer than what we would probably get at trial. And this has to do with game theory. Usually both parties have something to gain by avoiding trial, the prosecution and the defense. So when that happens, usually you collaborate and come up with a better solution that works better for both of you. But there are those situations where you come to an impasse and you're just stuck and you have to put it on the trial docket. And those are the cases I'm going to talk about right now. So the first thing to note is that the cases go onto a jury docket, but that doesn't mean you're going to trial that day. You get placed on a jury docket with maybe 8 or 9 other cases, and the judge calls all those cases and then makes the decision based on talking to the parties which case is going to actually go to trial that day, because of course there's only one jury. And you will need to be present for these jury docket calls, or at least available, because at the docket call you need to announce either ready or not ready. And if my client isn't there, I can't announce ready. The state also has to announce ready, and that means that they have to have all their witnesses ready to go. If their witnesses aren't ready, such as the police officer, and they don't announce ready, they can ask for a continuance. The judge does not have to grant them one. She or he usually will grant them their first continuance and often their second. But if they're asking for a third continuance and they don't have a really good reason, sometimes the judge will actually dismiss the case right then and there. Now, when choosing the case that will actually go to trial, the judge usually chooses the oldest case. If there's a defendant who is in custody, they will give that case precedent over another case where the client is not in custody, although that doesn't usually come up too much in DWI cases. Now, once chosen for trial, you have to think that it'll take 2 or 3 days, and you'll need to clear your schedule for those days, because of course you will need to be there. The first step of trial will either happen later that day or sometimes the next day, and that's voir dire. Voir dire is where you pick a jury for your case, and it's actually way more important than a lot of people give it credit for. Not only are you picking the people who are going to decide your case, but it's also a chance to give a first impression and to talk about some of the issues that are facing your case. It's very important. It's overlooked by a lot of lay people and attorneys, but it can often be the deciding factor in the case. After voir dire, it's time for opening statements, both from the state and the defense. And then after opening statements are done, the state puts on their case. Usually that involves officer testimony, sometimes an expert who talks about the BAC test. It could also include miscellaneous witnesses, whoever was there to see the person driving or witness an accident, whoever the state wants to put on to prove up their case. Following the prosecution's case, the defense puts on their case. We can call witnesses. I can call the defendant if we want. You do not have to testify. You can exercise your right to remain silent, but that's a decision we would have made before trial. Sometimes the defense doesn't have to put on a case, and all we would do is poke holes in the state's case through cross-examination of their witnesses. They have to prove their case beyond a reasonable doubt. We have no burden to do that. So we don't have to put on witnesses if we don't want to, and sometimes in DWI cases, we don't want to. Once the defense rests, there's closing statements, and the jury goes to deliberate. And at the end of it, there is a verdict. If there is a guilty verdict, we can request probation, and then the sentencing can go to the jury or to the judge. That will be our choice. Usually, we do request probation, and oftentimes we just ask the judge decide sentencing as opposed to the jury, because it can be more predictable. And that's a quick rundown on trial, but I kind of want to go into some of the reasons why you would take a case to trial. One reason would be is that you have nothing to lose. If the prosecution is offering something like probation with a conviction, that's what you would get if you lost at trial. So why not roll the dice, take it to trial, and if you lose, you're in no worse position than you had been. Another situation you want to take it to trial is if the prosecutor's case is weaker than they think. Oftentimes, I'll try and point out the weaknesses to the prosecution before trial, and this allows us to get the plea negotiations to a better place. We can avoid trial, but sometimes you have a prosecutor who's really dug in, they're really not looking at their case very hard, it's a weak case, and you can win. In that case, you put it on the trial docket. Sometimes, more often than not really, this gives the prosecutor a chance to look hard at their case, and they will drop the case or offer something that we will accept even on trial date. That's another thing to consider. Plea negotiations can continue all the way through trial, even in the middle of trial. If you can come up with a plea agreement, you can stop the trial halfway through and the jury's like, why are we even here? But it does happen. None of this has been legal advice, but if you do need legal advice on your specific case, you can visit us at atx.legal. If there's any more questions you have about DWIs, there is a link below for the PDF version of the DWI guide. You can click that or other videos on my YouTube channel.